there, but so you agree with respect to motor vehicles and safety regulations, it accounts for the safety belt regulation, it accounts for age limits and things like that. You agree that it also permits a hiring tort suit against the carrier. Do you agree that it also permits a tort suit against the shipper?
We do not agree with that, Your Honor.
So it stops with the carrier and only the carrier.
Exactly, Your Honor. And that's not to say there isn't rigorous federal enforcement. There are criminal provisions.
Why not the shipper?
The shipper, by imposing that duty on the shipper, and there are lots of claims against shippers, the shipper, by imposing that duty, this is like Roe. If you impose that duty on the shipper, then they're going to make different choices with respect to motor carriers. They're not going to allow new entrants. That will have an impact on the services of the motor carriers, and that's sort of how the court analyzed it in Roe. So I think it would burden them tremendously, and it would basically—
It's really a causation argument. You're saying it's just too far removed. It's a proximate causation argument, isn't it?
It's related to it, but I think it proves our point. We all know proximate—
If it's a causation argument, I guess I'm back to where Justice Thomas is. I understand the burden of these lawsuits. I appreciate that. But if you're, to the extent your argument hinges on causation, that is built into the state tort system in these cases. I suppose if there weren't a proximate cause element that's required, that might be a matter of some consideration. But there is.
The problem with that is it is baked into the state system. They want to be, in the words of the Ohio brief, laboratories of democracy. They're going to have varied standards. They're going to create a patchwork which would cause brokers and shippers and
well, right now we have a proximate cause standard before us, right?
In this
case.
Well, that's because petitioners are asking this court to assume Congress was thinking about proximate cause. It was thinking about—
I'm asking about the claim in this case. There's a proximate cause.
Yes, there is. But the problem is it's a nebulous concept. And I go back to the definitions and with respect to motor vehicles. Motor vehicle safety is defined as the performance of a motor vehicle in a way that protects the public interest against unreasonable risk of accidents occurring because of the design, construction, or performance of a motor vehicle. So when Congress used motor vehicle with respect to motor vehicle, it was, in this court's words, massively limiting the scope of the saving clause. And here, the brokers are too far removed. They don't touch the vehicle. They don't control it. They don't know what vehicle is going to be used. They don't know who the driver is, but they're performing a function relying on the federal authorization and licensing, which is what Congress intended. And so I think it's really important. And on the federalism point, I think the Nebraska brief points out that under this regime, the state with the most plaintiff-generous tort principles and proximate cause principles, they'll rule the United States. Everyone will have to adhere to those standards or avoid that state entirely. And that's why Congress felt that preemption was important here.
How difficult is it for a carrier to be authorized under federal law?
It's not nearly as easy as petitioners suggesting. Again, I think the regulations and the statutes speak for themselves. They have to show that they're fit. They have to show that they meet the various standards, that they will agree to hold drivers to certain standards. They do audit carriers. A lot of these complaints, we disagree with them about the FMCSA, but if that's a complaint, well, then they could do more or go back to Congress. And going back to the insurance point, yes, some carriers don't have significant insurance.